Good morning, everybody, and welcome to the August 2021 MLS presentation on the updates and changes to the Monmouth Ocean Regional Realtors Multiple Listing Service. My name is Brian Hutchinson. I'm part of the team here, and my objective today is to help you understand from the association's perspective the different changes that are coming into our multiple listing service. I have a couple of caveats this morning as we get started. First and foremost, from my seat, I'm not going to be able to monitor the chat, but I will be able to monitor the question and answer box. So if you're not familiar with a webinar, if you look in your menu, you'll see a question and answer section. When you have a question, feel welcome to ask it in there. We also have staff that's on this call who will be monitoring those questions as well, trying to help me ensure that we have given clarity around all the topics we're going to touch on today. Also, you should know that this webinar is being recorded, and it is being recorded for potentially for future training utilization. And so as we're in this webinar today, please know that any questions you ask may be part of a future recording and a future training. So with that being said, let's just jump right in, roll up our sleeves and get started talking about some really exciting things inside of the Monmouth Ocean Regional Realtors MLS. And those really come back to and start with our value proposition to you, our associates, our realtors here at Monmouth Ocean. And our value prop is that we're going to help you sell more. And part of that selling is listening to the market, listening to the things that are going on. And over the last 100 or so days, we've been doing exactly that. We've had in-depth conversations with our brokers, our owners, our designated realtors, and with realtor associates about what the issues they're facing in the marketplace are, how those relate to the multiple listing system, and what adjustments we can make to help them get better at doing business. And so from that, a task force, the MLS committee, as well as the board of directors, really began looking at the first kind of 85% package. This is one of 3 rounds of changes that are in the queue to take place over the next 6 to 9 months. And it really deals with these 3 areas. One, protection on post-dated listings. How do you protect yourself when you go out to do a listing presentation? How can you leave with a wet signature, have full protection, even if there's going to be a period of time before you begin marketing or showing that property? Secondly, was clarity or uniformity around the property statuses we have. How do we generate accurate definitions that help people use the same terminology, whether they're in Middlesex, Monmouth, Ocean, or any other county in the state of New Jersey or in the surrounding areas, New York, Pennsylvania, Connecticut, where people are practicing real estate. Thirdly, what do you do as a listing agent when the owner of the property says enough is enough, stop showing the house? And the current rules and mechanisms, there's not really a way for you to do that, because the listing agreement says that you will show and market that property up until the time that it's closed. And so we've made a series of changes all around those kind of 3 topics in an attempt to alleviate some of the chaos and some of the confusion in our marketplace. So we're going to begin by looking at some changes to the listing agreement in whole. There are about 12 different changes. Most of them are grammatical or are aimed directly at a specific type of protection, like the extension of the listing agreement to heirs, to other owners, some protections, additional protections around a protection period. But the biggest change has to do with facing the topic of the post-dated listing. Let me paint a current scenario picture for you. Currently, let's say that Realtor A, Agent A, goes out to the marketplace and they have a listing presentation on a Sunday afternoon. Everybody is in concurrence. The offer to provide services has been made. The owner of the property wants to accept that offer, but the property is not going to be ready to be on the market for another 3 weeks down the line. They could change the carpet, paint the floors. You're going to get some professionals in to do some staging, whatever the case may be. The current practice to cover that period of time has been to either misuse the office exclusive status or misuse the coming soon status. When in reality, what we needed to do was move from 2 dates in the listing agreement to 3 dates in the listing agreement. So with counsel, our legal counsel here at the association, we've affected that type of a change in the listing agreement. It can be found here in paragraph 1. And now that change looks like this. It adds some language that says the right to sell, lease, rent shall begin on such and such date of month of such and such year. That is the commencement date, and shall then expire on such and such day, month of year. That's the expiration date. So we've gone from having 2 dates in the contract, the effective date or the date that it is signed and the expiration date, to now having a 3rd date, which indicates the commencement date. And loosely defined, that term commencement date means the date by which you can begin marketing and showing that property, doing both marketing and showing, or marketing and or showing of that property. Now, there's some differentiation between that and a coming soon or an office exclusive, but let's focus really in on this. And so in practicality, under the same scenario that I just painted for you, if you were at that listing agreement on a Sunday afternoon, everybody came to terms, they loved you, you could leave that listing agreement now with a wet date, and that would be a wet signature, and that would be the effective date of that listing. That's the date that it's signed at the bottom of the listing agreement. And you would be fully protected in that listing agreement even before you begin the activity of marketing or showing that property, which is the commencement date. And so here's a couple of pieces of language inside of that for you. One, you'll see that the owner is clearly told, or the owners of the property are clearly told, that this agreement is binding on the parties and is in full force and effect as of the date it is signed. In other words, the date that you date this listing agreement on the bottom of the listing agreement, at that point in time, this listing agreement becomes fully enforceable. It is a contract. However, you're also agreeing that no marketing or no showing of the property may occur until the commencement date. That is the date of signing through the expiration date is then called the term. And so this pre-commencement period is part of the term of the full agreement. Now, what you really need to know is that this is intended to clarify that no marketing and no showing of any way can happen by any person during this pre-commencement period. That period of time is there to protect you, and it's there to protect your broker. So when you're investing the resources of time and effort and energy and money into getting a property ready to come on the market, the owner of that property is less likely to change their mind and choose to go with somebody else who has the newest, latest, greatest, best offer for them. This is a protection for you, so that when you start investing in the selling of that property, in the marketing of that property, in the generation of interest around that property, you are protected. So the date the listing agreement is signed is the effective date of the contract. The date that you start to market or show that property is the commencement date. Now, if you have questions around this and you'd like to put those into the Q&A section, I'm able to see those and I'm glad to deal with them. Let me share with you a couple of questions that have already been asked. So one of the questions that have been asked that we want to bring your attention to is, what happens if the owner of the property starts marketing it? They tell a neighbor or they post it on social media or something like that. What happens to this listing agreement if it has a pre-commencement date and the owner begins the process of marketing? Well, at that point in time, you as a listing realtor would have 1 business day to enter it into the listing in an active status, or be subject to enforcement even if that marketing happens by somebody else. And so this is really important to know. Marketing means the marketing of the property, and that is not limited just to your activity or your office's activity. That is also conveyed upon the owner of the property. From the MLS perspective, we have no control over the owners of the property or limited control over the owners of the property. So we will be looking to the listing realtor to ensure that no marketing of that property is happening at all. And if that's discovered, that you take the appropriate actions, either get the marketing down, get it off, or get the property fully listed in active status inside of the MLS. Another question has been commonly asked with this is, can that property be shared inside of the office? The answer to that question is no. Marketing is marketing, and the listing realtor, if they were to do that, begin marketing inside of their property, they'd have one business day to enter that listing into the MLS, or they would be subject to the enforcement activities of the MLS, education fines, suspension of services, those type of things. Even if that marketing happens again by somebody else. And so we've had great conversations, in-depth conversations with our brokers and managers about this, because the brokers and managers obviously will know about these listing agreements and about making sure that they are not shared inside of the office. Another question we've been asked is, does this replace the office exclusive or the coming soon? Absolutely not. Those are both allowed under the rules and regulations of the MLS, and they are subject to the rules and regulations, or subject to the enforcement rather in the rules and the regulations of the MLS. Office exclusive is a status, coming soon is a status. Those are types of property transactions that are separate from this. This does not replace them. And so I'm going to deal with a couple of other questions here. So what if the one day to put it in the MLS is before the commencement date? Do you have to change the original commencement date on the listing agreement? The answer to that question is no. You simply have to affect the change inside of the MLS. You do not have to affect that change. Because marketing has happened, that propels the property forward inside of that listing agreement. So how is that protecting the agent? What is the agent is not aware of marketing? So Susan, the answer to that question has to deal with enforcement, and this is really fundamental to the philosophy of our association. Because we strive as an association to treat all of our agents actively, we act when we have been made aware of a violation or a potential violation. So let me explain that to you. So let's say that on Monday, somebody puts something on social media, but on Wednesday, we don't find out about it until Wednesday. We look at that timeline from Wednesday, not from Monday, because we're not in the business of proving out evidentiary or taking evidentiary activity of proving out evidence. We look at it from the specific time that we have been made aware of it, because that usually is generated by another participant in the system. So that's how that protects the agent. So if we find out about that marketing, if it happens on Monday, we find out about it on Wednesday, we're going to contact you, and you'll have one business day from the time you're contacted to get that into the MLS. There's another statement that says, is there a document for the seller to sign that they cannot market their property until the commencement date? Yes, it's in the listing agreement. The language in the listing agreement says that both the owner and the realtor agree that no marketing or showing of the property will happen until that commencement date occurs. So when they sign that document, they are understanding that. This is why it's important, just like all terms of a listing agreement, for you as the realtor associate to make sure that you've explained that to them. How long after the effective date can the commencement date be? It can be the exact same date, Don. It can be on the same date as the commencement date. By our rules, it's 180 days for new construction, 30 days for all other types of property. We'll cover that in just a moment because we're going to talk about how this translates to the protection inside of the system. A similar question, is there a maximum length of time you can have this listing before the commencement date? Yes, for our MLS purposes, that's 180 days new construction, 30 days for everything else. What if the seller decides to start showing the house before the commencement date? Do we have to change the listing agreement? You do not have to change the listing agreement, but that triggers then Clear Cooperation 8.0, which means you have 1 day to activate it or put it into the MLS in the appropriate status. And that conversation is the conversation you then have with the owner when they say, why is that doing that? And the answer to that question is, in this scenario, because you, the owner, violated the listing agreement we've entered into, and the rules say that this is what we have to do. And Wiltz asked, just to be clear, you cannot announce you have a listing coming on at an office meeting until the commencement date. That is correct, and you're right about that. When it's in this pre-commencement period, it is not a coming soon. Coming soon allows you to market, which would include announcing that at an office meeting. Pre-commencement, there's no marketing, no showing. The best way to look at this is that this is your time to invest in that property, to take your experience, your expertise, your resources, to have the house photographed, to do everything that you do, create the marketing pieces in the background, do that work so that on that commencement date, whether that's the same day, 3 days, or 30 days, you are fully ready to begin the process of generating audience around the commodity that you're selling. Because that's what you do from a listing perspective. You work to generate the biggest audience you can so that you can create the best offer for the seller of that property, meeting the terms that they want to have. If you have more questions about this, we'll come back to it. But I see that the question block now is open. I do want to remind you that if you're posting your questions in the chat room, the chat is not being monitored by the panelists, so you'll want to put those questions into the question and answer block section. What I really want to clear about this is no means no. Again, this is a protection for your brokers, it's a protection for your DRs, and it's a protection for you. This allows you to not have an open period of time where you're not protected. You can get that live signature on a listing agreement, begin investing in that property to generate the audience, to sell the property, and have less likelihood that your seller, your owner, is going to depart from your agreement. This gives you protection. We're asking you, please do not abuse this. All right, so we're going to move on and talk about statuses now. So to give you a picture, our MLS has grown significantly. We're now in every county in the state of New Jersey, except for 2 being actively used. You can put your listings, no matter where they are in the state of New Jersey, you can put them into the Monmouth Ocean Regional MLS and utilize that as an MLS system for you. And because there are different practices and because there are different activities throughout our geographic footprint, we felt it necessary to really hone in and define what some of the terminology is. And so we went to RESO, which is the Real Estate Standards Organization, a nonprofit organization that works with National Association of Realtors and the Council of Multiple Listing Services. And it creates standards that are utilized throughout the MLS industry. And so as a realtor-owned association and realtor-owned MLS, which we are not a corporate MLS owned by some third-party company someplace or some limited group of brokers. We are owned by the totality of our membership. We felt it best to create rules that reflected that. And so we have adopted the RESO standard definitions with some slight variances because of our marketplace. And those statuses are now clearly displayed in the rules and regulations and Flex and on the websites of Monmouth Ocean. And so I want to take some time to talk about those statuses. The first status that you're going to see is a hold status. And we are the only MLS that we know of in the state of New Jersey that offers you this hold status. And the hold status by definition says that a contract exists between the seller and the listing member. The listing is completely off the market and it's not allowing any showings or marketing. This is that pre-commencement period that we just talked about. And so now you as the member have a voluntary status, not a mandatory, but a voluntary status that you can utilize for the best practice of business inside of your business model. And that's called hold. And so let's just say that you have this property in a pre-commencement and you want to make the rest of the marketplace aware that that property is off limits you can put that in the hold. If you don't want to use it, you don't want anybody to know about it, you can also put that in the hold. What you have to know is that the rules allow for 180 calendar days for new construction, 30 days for everything else, in that this is voluntary. And so it does not meet the criteria of Clear Cooperation 8.0. So where Clear Cooperation says you have to submit something to the MLS, this status does not meet that. Let me show you how you would put this into a hold status and how you would check that hold list. So you would open up Flex MLS and you would click on the menu button, and on the menu button, you would scroll down until you see the section that says products. And under products, you'll see view, enter a hold property. You simply click on that link and it brings you to this website, which you can also directly go to if you want. You could save it to your favors, which is monmouthoceanrealtors.com/hold/. And you can see this gold box, which says, please click here if you would like to submit a property to the hold section. If you click on there, it gives you a very simple form to fill out, ask you for the property address, the name of the listing brokerage, and your name. That is all of the information that is displayed. The price of the house, the size of the house, the neighborhood the house is in, the color of the car, none of that information is shared. The only thing that is shared is the address information, who the listing agent is going to be, and who the listing brokerage firm is going to be. You can actually see those on a list on this website, and it looks like this. So when you submit a property to the hold status with the MLS, this is all that is seen. This is what it's going to show to the general public. So let's talk about why you would not want to use this hold status. As a matter of policy inside of your brokerage firm, which that policy should be set by your broker, your designated realtor, you may choose that you don't want to use the status. And you may choose that you don't want to use the status because you just don't want anybody to know that this property's come on. You don't want to deal with the potentiality of marketing. You don't want to deal with the pre-phone calls of other agents calling in saying, I see you've got a property to hold, tell me about it, which of course you can't do because that is a form of marketing, by the way. I can tell you that a practice that is common in our marketplace right now is for people to see a property incoming soon, to make phone calls, to set up a showing, and then file a complaint because of the abuse of it. We don't want that. We're not here to be hammer swingers. We're here to help you sell more. So let's talk about why you might want to use the hold status. And I see the question in the hold in the Q&A from Donna saying, what are the advantages of the hold status? Well, here's the biggest advantage of utilizing the hold status. This list now exists. So let's just say in the example here being used of 123 Main Street, that you happen to live at 125 Main Street. You're a real estate agent and you see a dumpster outside that house. You know that it's an estate property and you're thinking, man, I should go try to get that listing. They're obviously getting it ready to sell. There's a dumpster there, carpet's being changed, there's paint trucks. Before you go look at that property, you might want to check this list and see, is 123 Main Street on this list? Because if it's on this list and you go and knock on that door and try to solicit that listing, then you may very well be violating Article 16 or other articles of the Code of Ethics. And those Code of Ethics come with enforcement activities. Likewise, perhaps you are in the process of doing cold calling. You just go knock on doors and you decide in any town, New Jersey, you're going to go to Main Street this week and knock on the doors. It would behoove you to check this list, because if somebody has a property and they have submitted it to this list, this is available to our professional standards and our compliance department. And if you're attempting to poach a listing that's in the hold status, it's kind of hard to defend against that if the person who has that property in a pre-commencement has taken the time and the effort to submit it here. So the answer to this question for you is that the advantage of this is it gives you a level of protection by telling those people that you cooperate with, that you've agreed to cooperate with, that I have this property. Let me tell you one other advantage to this. One other advantage of this lies in the fact of what you can and can't communicate. So you can see that there's an address here, but there's no information about a property. So if I were a buyer's representative and were representing somebody that was really interested in the house at 126 Main Street, I might check this list. And before I got into a massive bidding war and they felt like they're totally going to lose, I might have the capacity to say to them, listen, it's not on the market. We don't have any information about it right now, but within the next 30 days, there is another property that's coming on the market on this street. And that's all what we know. And so don't feel like this is the only property on this street, in this neighborhood, on this block, whatever the case is. There will be, and it's a tool for you to refer to. Again, the listing agent cannot do any marketing. This is not considered marketing. This is considered the pre-hold status and an awareness in the eyes of the MLS to the marketplace. Tina is asking the question, what happens at the end of the 30 days if they're still fixing up items in the house and they're not ready to put it on the market? Well, Tina, that becomes a matter of conversation at the brokerage level. From the sake of the MLS, we only recognize 30 days on this list. A property can only be submitted to the hold one time by a listing agent. Now, we do not require the utilization of our listing form and our listing agreement. You, as a member of this MLS, you are allowed to use any listing form you want as long as you collect the required data. But this property, this list is here for you just to show you what's on the market and to grant some extra levels of protection. If you go beyond that time frame, the property will be removed from this list. It will not be seen by the other participants of the MLS system here in Monmouth Ocean. And so one of the questions that Elizabeth is asking is a statement that says, if I'm not allowed to tell my fellow agents about the listing, but in the hold status, it will be on Flex for all to see, isn't that marketing? And the answer to that question is no, Elizabeth. Actually, the listing is stored on our website, not actually in the Flex system. It links over, number one. And number two, under the way the rule is written inside of our MLS system, the way that our MLS committee and our board of directors crafted that rule, this is not considered to be marketing. It's not considered to be marketing because this is simply an awareness. It does not give any of the product details about the house, the size of the house, the characteristics of the house, the price of the house, when the house is coming on the market. In the status, there is no marketing and there is no showing allowed. If we find that that has occurred, that somebody has a pre-commencement date and that they have shown or marketed that property in a flagrant manner, that will be considered an egregious violation of the rules. And as you probably know, egregious violation of the rules, has a higher level of enforcement. So it's not only fine, but also potentially suspension or removal of MLS services. And so don't do it. Don't market the property. Again, this is a tool for you. What about listing agents? What does the listing agent do if the buyer's agent calls him or her about the property in hold? That's a great question, Ann. And so what I would tell you is that the property is in hold. You answer that, you simply say that property is in hold. And as you know, by the rules of our MLS, we're not allowed to market or show it. It'll be coming on the market inside the next 30 days. And you just limit your conversation to that. You dive away from the propensity to be nice, from the excitement of sharing the information. Make a commitment to call that person back, let them know about that property when it comes on, when it's available to be marketed. But when they call, you just simply say it's in the hold status. And by our rules, we're not allowed to do any marketing or showing of that property. Can an agent put any house under hold without paperwork, without written authorization from the seller? Absolutely not. That would be a prohibition of action actually by the Real Estate Commission. Inside of our rules, there is no mechanism that a property can go into the hold status without having a listing agreement that gives you a pre-commencement. And so whether that's our listing agreement or somebody else's, you absolutely can't do that. Can we tell our office that we have a property entered into hold? Kelly, that's probably parsing words. I guess the answer to specifically your question is you could tell somebody else you have a property entered into hold, but that would be the limitation of what you can share. I don't know that I'd even want to publicly disclose that because it's inevitably going to lead to a conversation that will potentially become an egregious violation. Again, look at the intent of this. The intent of this is to protect you. The intent of this is not to create a workaround. The intent of this is to answer the requests from our brokers and our owners that are looking out on behalf of you, the users, and find a way to be able to protect the listing. So when you're investing your time, your money, your effort, your resources into getting a property ready, you are fully protected or protected to the highest level standard that we can do. That's what this is. One final question on this. What is the intent of the hold status if coming soon already exists? Simply to tag the property so other agents can't attempt to list. Again, it's to create that protection. In coming soon, you can market a property, you can't show a property. In hold, you can neither market nor show a property. Now, you're going to see as we move forward here that the next status change is the coming soon status. And one of the monumental changes is because this hold now exists for you, coming soon has actually been reduced to 7 days. Now, I can tell you that there is active conversation in the association that coming soon should just completely go away because of the abuse around it. The greatest occurrence of enforcement activity in our MLS comes around right now, the coming soon and the abuse of the coming soon. And so there is conversation of actually removing it because of the chaos that it creates. Right now, it's being reduced to 7 calendar days. So a coming soon status is now 7 days, not 30 days. So if you currently have, what you need to know about that is that if you currently have a property in the MLS and coming soon, it will remain there until your original date. And so if it goes in July 31st as 30 days and coming soon, it'll be there. If you make any change to that, or if the initial entry period ends, it will go to the 7 days period. And so you have a little bit of grandfathering there for you on that, but as of August 1st, coming soon is only 7 days. And so you need to be aware of that. Remember what 7 days is about. 7 days is that coming soon, up to 7 days, I should say. Coming soon is about generating an audience around your property. It is about utilizing marketing techniques to get an audience for your property. It's not intended to be kind of the make ready timeframe. It's not intended for you to start showing the property to your own personal clients. It's not intended to work around the rules. Those are egregious violations, and those come with the potential even penalty of the suspension or loss of MLS services, the inability to utilize the MLS. And that actually does happen. And so you've got to be careful about that. We take this incredibly seriously. We have to, because our role is to create an orderly marketplace, not a marketplace that's earmarked by confusion and chaos, but rather by order, compensation, and cooperation. So coming soon will be 7 days. If your sellers absolutely aren't ready for the listing to go active after the pre-commencement period, i.e. still clearing out their parents' home, could you then utilize the coming soon status to buy them 30 more days before showing? No, you have 7 days, and it's 7 days you can begin marketing activities. So that's it. What I would recommend to you is that if you don't have, if they're not done, they're not ready, I wouldn't recommend to you using the coming soon. I'd recommend to you having a conversation with your broker about what listing agreement you're using and whether or not you can amend that listing agreement. Now, that may mean that a property no longer has the protection of the hold list, but it may mean that you have in your office the mechanism in which to extend that commencement. I have to make that caveat and remind you that I am not an attorney. I'm not here to give you legal advice, nor am I a broker in the state of New Jersey. And so I can't give you real estate practice advice. What I can tell you is I'm the chief administrator of our multiple listing system. And my role here, my job here is to help you understand what the rule is and why the rule is in place. Where will the hold status appear? You said it would not be in the MLS. I did not say it wouldn't be in the MLS. I said it wouldn't be on the Flex. The rule, the hold status actually appears on the Monmouth Ocean website. You access it either from the Monmouth Ocean site or from Flex. It doesn't show up on your Flex property list. It doesn't do that because it is not distributed anywhere outside of our immediate area. Hold status doesn't go out to any third party like from our system, like a realtor.com or Truly or any of those different sites. It's only available to our users on our website. All right, so let's talk about another change that's coming soon. The coming soon amendment form that you fill out has gone away. That amendment language is now on the standard amendment form. So the C11, the amendment to list form that we have, it now has the coming soon language on there. The reason for that is so that you have one less document that you have to keep up with, and you have one less document that you have to explain in totality to the seller of the property. It's intended to streamline it so that coming soon language, that amendment still has to be filled out. It just happens now that it is on that C11 amendment to list form. You can find that in Flex and in the document sections of our MLS. The next property status we want to talk about today is the active status. Active status simply says this: the listing is on the market and an offer has not been accepted. It's pretty simple. If the property is available to be purchased, it should be in the active status. If there's no offer on it, it should be in the active status. If a property is in the active status, it must be available to be shown to participants within reasonable hours. And so you cannot, if you utilize a showing service such as showing time, you can't block out a property in active status for multiple days at a time, right? That's not the intent of active. That would be temporarily off the market. It's a different product. Active means it's available to be shown. It's available for other participants to bring their clients to look at this property with the intent of purchasing this property. I think that should make sense to everybody there. Now, there are two statuses that are unique differences, and we want to make sure you really understand these. Those two statuses are the active under contract and the pending status. I'm going to start by giving you the basic definition. Active under contract says that an offer has been accepted, but the listing is still on the market and is still available to be shown, right? So you have a contract, but the property is still available to be marketed. It's still available to be shown. Pending says that an offer has been accepted and the property is no longer on the market or available to be shown. So the difference between active under contract and pending really has to do with the intent of the seller. And this is the way you should look at that. If the seller says it has a contract and they say, keep showing my property, then it should be active under contract. If the seller has an offer accepted on the property, a contract, and they're like, I'm done, I'm not interested in showing it any longer, take it off the market, stop it, then that property would then go into the pending status. There's a couple of caveats with that. Offers that are in pending status, or properties that are in pending status offers still have to be submitted in conjunction with the laws of the state of New Jersey. As you know, New Jersey requires you submit all offers to the seller up to the time of closing. Likewise, if you move a property directly from active status to pending status, that requires a signed amendment by the owner to be posted to the document section of the MLS. So we're going to talk about that for just a second. Let's talk about it. And I see the attorney review question up inside of in the Q&A. So let's talk about that for just a second. Again, I'm not an attorney and I'm not here to give you legal advice. I'm here to explain to you the rules of our MLS. And some of these are matters of policy decision for your local brokerages. And so I would always tell you to lean on what your brokerage says to you. So with that said, let's talk about what attorney review actually is for just a moment and how it applies to the multiple listing service. Attorney review is not a status. Attorney review is an action connected to a property, much the same way that an inspection is an action, that the verification of underground oil tanks is an action, that getting repairs done is an action, that a contingency to a contract, that is an action. Attorney review is not a status in the state of New Jersey. Attorney review is a carve out in the statutes that gives the two parties entering into the contract the ability to have the contract evaluated. In fact, when you look at the law around attorney review, what you will find clearly written in that law is not the word offer nor the word instrument. It is the word contract. Attorney review is the review of a contract between a buyer and a seller, right? So let's understand that. So when does an offer become a contract? Well, when offer is made and acceptance is reached, then that becomes a contract. And that is the point in time in which a property should transition. Now, there is a question of how long do you have to transition that property from the active status to the active under contract or pending. And the answer to that question is it's kind of undefined. The general rule is 4 to 5 days that property should transition, or when the seller of that property tells you to make that transition, it should happen. The law of the state of New Jersey says is that if you have a property that is under contract and you're continuing to market it, it must have the language under contract involved in that marketing. And so that's the reason for this change, right? So Kelly writes in the questions answer, accepting an offer and out of attorney review are two different things. Shouldn't pending be an offer is accepted and is out of attorney review? No. In the eyes of the multiple listing service, attorney review is an action connected to the transition of a property. And therefore, attorney review is the review of a contract by New Jersey real estate law. And so to answer that question, the reason that the task force, the MLS committee, and the board of directors, along with the legal counsel of our association, crafted the rule the way that it is crafted is to both allow your broker to make a decision if their attorney or legal counsel tell them something else, but to recognize what the law says and to recognize the intent of the seller. And this is really where it comes back to in the MLS is what is the seller telling you to do? Tricia has asked the question, do you have to wait until attorney review still to market pending? You do not. But if you go from active status, Tricia, from active status directly to pending, then you do have to get an amendment signed by the owner of that property. So let me talk about that for just a second and the why that exists. As we know when we move from theory or philosophy to pragmatism or the practice of something, that there are oftentimes disconnects, unexpected that can't be dealt with. An example, you put a property into attorney review, which doesn't happen in our entire footprint, but let's just say attorney review happens. One of the common practices that we see, that we know of, is that immediately going into attorney review, the attorney kills that contract, and then they start effectively a new contract and working out the details. And they do that so that they meet the 3-day time restraint and give everybody time to breathe and work through it, right? Well, it's not our job to get into semantics of that legal transaction. That's really a matter of business practice and policy that your broker, your designated realtor deals with. And so we look at it as that property. Is that property available or not? And what has that seller said to do? So it's potential, right? Or probable that a property goes under offer and it's kind of an iffy offer. Maybe it's an offer becomes a contract rather than it's iffy. There's contingencies involved. The sellers are asking for things the buyers aren't sure of, they don't know. And that seller really wants that property to still be marketed and shown. They're soliciting backup offers. They want those to come in. The property would go into active under contract status. If that seller says, I'm good, I'm tired of 27 showings a day. I'm tired of everybody and their brother coming through my house. I need to stop the showings on this property. The reason that you have them sign the amendment is because attorney review might not be 3 days. It might be 3 weeks as you're working through issues. And what you have to make clear to that seller is that during that time, if that property is in pending, it's not in the MLS, it's not being syndicated, it's not being shown, it's not being marketed. We're not doing anything to generate any more audience around that house. We've stopped showing it and we've stopped marketing it. And so you've got to give us permission to do that because time is of the essence. And if this attorney review, it gets protracted and we've lost that time in the market, then the market may have changed. And so this carve out in the rule is really for your protection. This is here to protect you against the liability, against the litigation that's already starting to happen in this crazy market where deals have fallen through and the seller says, I've lost out on an opportunity because you gave me bad advice. This is intended to give you that protection. So the overall question you should be asking yourself about moving the property from active to either active under contract or pending is really what is the intent of that seller. Let me also make one other statement, and that statement is while you're required to use this amendment, if it goes from active to pending, you can also use this amendment if it goes active under contract to pending. And so if you choose to do that as an added layer of protection, this is here for you. So let me stop and answer a couple of these questions. If there's an accepted offer, but it is not yet out of review and the seller no longer wishes to show the home, do we still need to complete the status amendment? So what you're saying, Jenny, is effectively that the property is going to go from active to pending and it's going to be in pending while it's in review. That is a case where you would need to fill out this amendment and submit it to the document section in the MLS. The attorneys cancel the contract with their first review letter, making it active again. So Kelly, that does happen. It's not constant, it's not consistent, but that is something that happens. And this is where we want to, as an MLS, give your broker the opportunity to really make that decision around policy in their association. I guess the best way of saying that is that's not a sword that we're dying on. That's not the biggest battle in our mindset. What we really are interested in is that you have the protection to represent what your seller tells you to do. And if the seller says keep showing it, it should be an active under contract. If the seller says stop showing it, that's when you put it in the pending status. What is the status when the attorney review is concluded? Elizabeth, that's a very astute question. Typically speaking, that's going to be pending because your seller typically is going to be like, I'm starting to get this house ready to go. But the reality is in the market that we actually have sellers right now, and part of the reason for this change as we listen to the market, listen to our brokers, we have an abnormal amount of sellers that are saying, even after attorney review, put this, I want you to still market and show this property. I still want it to be on the MLS. I still want it out there because if something falls through, I want to have backup offers. I'm just not sure about this. And so if they still want it marketed, it would be in active under contract. And what we'd ask you in that point in time is to put a note in the agent remarks of the MLS that says this property is active under contract, but is out of attorney review or something to that effect. David asked the question, if it's out of review, do you still need the amendment in place as pending? The only time you have to have that amendment is if you go from active directly to pending. If you go from active to active under contract to pending, you don't have to have it. But if you go from active to pending, if you go from this house is fully marketable and showing to this house is completely off the market and not showing, it's not syndicating any longer, that's when you have to have that. You have to have that amendment. You can choose to use that amendment if you want that added layer of protection where the seller is submitting and they are saying in writing that this property is no longer in the market and available to be shown. You can still utilize that if you would like to do so. All right, let's talk about a couple other statuses real quick, and then I want to give you some scenarios. The closed status says this: the purchase agreement has been fulfilled or the lease agreement has been executed. And canceled means that the listing contract has been terminated. Terminated means it's done, it's over, there's nothing outstanding. It's free. Somebody else can pick up that listing and carry on with it. Let's talk about two other statuses. One is called, that you're going to see now, is called temporarily off the market. And temporarily off the market can best be described as a pause period. And that says that an active listing is temporarily off the market and is not being shown or marketed in any way. And this is intended to be a short-term solution to something that's occurred. An example, let's say that ABC Realtor has a listing on my house. I trip, I break my leg, and I've got to be in a recliner for 3 days. And I don't want people coming around while I'm sitting in a recliner in my pajamas in my living room, but I still want my house to be sold. I could say to my agent, ABC agent, please just take my house off the market for a couple of days. Give me some time to adjust and to figure out how to get out of here. That would be temporarily off the market. I'm going on vacation. That would be temporarily off the market. The hot water heater broke and we have to get some repairs done to the house unexpectedly. That would be temporarily off the market. And during that time period, you're not allowed to show or do any additional marketing on that property. Excuse me. There's also a status in the MLS called withdrawn. And withdrawn says that the listing has been withdrawn from the market, but somehow there is a contract that still exists between the seller and the listing member. So where in temporarily off the market, it's the intent that that property is coming back on the market. Withdrawn means there is no intent for that property to come back on the market. We're working out the details of how we're ending our agreement. If you're using withdrawn listings, your broker gives you permission to use those. Then you simply do that by also using the temporarily off the market status. You just put a note in the remarks that say this property meets the definition of withdrawn. And that is an indicator to all of the other participants that this property is not just off the market for a couple of days, but rather this property is going away. You've been directed to stop showing it, stop marketing, and you're working through those details. That's a mechanism to hopefully slow down some of the telephone calls that you're receiving. The listing contract has been expired is the definition of expired. Is there a time limit for temporary off the market? Currently, there is not, Christine, a time limit for currently off the market. Probably this fall, as we see how that works out, there may come a time period, but currently there's not a time period on that. Another question is, with the temp off the market status, do you have to take down the property marketing and for it stand up? Roberto, to answer that question is whatever is reasonable to take down, yes, you should. So if it's going temp off the market, you should go take the sign down out of the yard. You know, if it's going to be off the market for 2 weeks, go take the sign down and lay it down. If it's going to be off the market for a day, you know, you're within the 1 day of affecting a change rule, so you don't need to do that. You do not need to end previous marketing that is not easily ended. An example, if you created a magazine article or a newspaper article, we're not going to make you go take those down. But you can't make a new social media post. You can't actively engage in communicating on previous posts on social media, right? So if you had a social media post that this beautiful house is available, now it's off the market, you can't go back in there and still work on that. The intent of that is that you're not marketing, you're not showing the house right now, you're giving your seller a pause period. Can you use temp off the market while in attorney review? Laura, that's a question really best answered by your broker. In the policy that they set inside the office, there may be some who want to take that approach. From the MLS position, though, once offer and acceptance has been made, and that is a trigger point that it should be changed. And within a reasonable time frame, it should be changed to either active under contract or pending, depending on what your seller wants. That again is not the hill that we intend to die on, to use an old parable. This is really a business decision, and there are some attorneys we know that counsel their brokers to do things like that, and we're not going to get in the middle of that business decision. Is there still a conditional and not conditional off the market status? Alan Kale, no, there are not. It's now temporarily off the market and withdrawn under temporarily off the market. So the under contract continue to show status has been eliminated and has been replaced with these RESO definitions, which again, I want to go back to just to touch on that, is that these are the national standards. What we've implemented in our system should be consistent and will be becoming more and more consistent, whether you're in California, Texas, Pennsylvania, or New Jersey, wherever you happen to be. These are the RESO standards. NAR's best practices say that these are the standards that we should be utilizing so that it's easier and it makes more sense to you, the realtor and realtor associates practicing business. So can I show a property while it's in hold status? Nope. No means no. No showings. What about attorney review? I think we covered that in depth. We don't deal specifically with attorney review, as that is not a status. That is an action that is being applied to a property that's under contract. When does an offer become a contract? It becomes a contract at the point of offer and acceptance. Here is a picture for you of what the typical life cycle of a property looks like. You're going to sign a listing agreement. You're going to create a hold status if you so choose to do. It's voluntary. You don't have to. You may not even have it. At the end of that hold status, you may choose to move it to coming soon. If you have some reason that you need to generate a bigger audience around the property, you'll have 7 days to do so. From coming soon, it most probably will move to active status. The property is ready. It's now available for the entire world to see. It gets a contract on it and it moves either to active under contract or pending. Typically, it's going to move to active under contract until all of the attorney review is done and your seller says stop showing it. But whenever your seller says stop showing it, it goes to the pending status. And from pending, you're going to hope that it moves to the sold status. So let me give you 3 scenarios. 1, an active property receives an offer. All parties sign it. They send it to attorney review. Then the property comes out of attorney review, and then the owner does not want to market or show the property anymore. That would look like active while it's in active status. When all parties have signed, it would, in a reasonable time frame, move to active under contract. In attorney review, it would stay in active under contract. When attorney review was done with, because the seller doesn't want to show anymore, it would go to the pending status. Likewise, let's say it's a little different. Active property receives an offer, everybody signs it. The owner says no more showings or marketing the property. Then the contract goes to attorney review. Then the property comes out of attorney review. Well, in that scenario, it'd be active while it's active. Once everybody has signed it and the owner signs the amendment, it would go to pending, and then it would stay in pending for the remainder of its duration as a listing up to the closed period of time. What about third scenario? And the only thing different here is that the owner wants this property to be shown and marketed indefinitely. Well, it would go from active to active under contract, and it would stay active under contract with the note in the remarks saying that it was finished up, that it's out of attorney review. That's a courtesy comment. It's not required, and it would stay that way until the property has closed. So I've seen a couple of questions. Will the slide presentation be available? Yes, this slide is actually available to you. There is a link on the website that has all of these updates. It also will have some short videos to help you understand stuff, as well as one of the recordings of the webinar. And so you can get there. Can a property go from pending back to active under contract if there's a problem? Absolutely, it can, Jeffrey. You can move it from active contract to pending and pending back to active contract. It can go from pending back to active if it falls through or something like that. You can do that. Can we get a copy of this recording? Yes, Jacob, this recording will be available, or one of the recordings of the webinars will be available on the website in just a couple of days. Who's going to monitor the pending amendment? Those amendments get sent in or submitted to the document section of the MLS when you have those. And when there is a need for us being the MLS, to evaluate those, they will be checked. They will also be checked as part of the ongoing audit system and audit mechanisms that we have in place from staff, where we periodically audit listings actually on an ongoing and regular basis. We're monitoring listings, auditing transactions, just making sure stuff happens. Elizabeth asked the question, if an offer goes from active under contract, concludes review, and then pending, do we need the amendment signed by the owner? The answer to that question is no, you don't have to have it signed. You can still have it signed if you want that added level of protection. That's a matter of broker policy. And it's something that probably should really be decided is, do we want the extra protection? Because that gives the written recognition from our seller that we no longer want this property to be marketed and sold. Are these all of these changes are effective August 1st? Yes, Kevin, they're all effective August 1st. You can start using the documents now if you'd like. They're open and available for you. Let me answer one other question that's been asked, just for you know, and that is, what about buyer's protection on this? You know, what did the MLS committee, what did the task force, what do they think about the buyers? How did the buyers get left out? Well, the buyers actually aren't left out. Because as a matter of policy, which again, I'm not here to tell you or your brokers what the policy internally should be, but you have the ability in your contracts and offers to write clauses. And so if you represent buyers in this market, one of the things you might ask for is that provision. You might just say as a provision of the contract, something to the effect of, hey, upon execution of this contract, property shall move to the pending status within 3 days or 5 days or something like unto that, to get that little bit of protection against the property continuing to be shown and marketed. That's a current question we've been asked over and over again. That's a matter of broker policy and how you write your contracts, how you write your offers that turn into contracts. And so have that conversation. We've had that conversation with the owners and brokers and designated realtors here. We encourage you as a realtor associate to do the same thing. I see no other questions inside of the inside the Q&A box. I am looking and I see that Ramit has his hand raised, that he has a question. Ramit, if you have a question or you want to unmute yourself, you can ask that question. Okay, I think that perhaps is an error, so we're going to lower that hand and move on. Where can we rewatch this video? The video can be found on our website. There is a page dedicated to these changes on the Monmouth Ocean Regional Realtors website, monmouthOceanRealtors.com. You can go there. There's an entire page that's dedicated to this. The recording of this webinar videos won't be up for a couple of days. We're working it through the Zoom process, webinar process, to get it converted into a shareable video as we go. But it will be up there in the next day or two. All right, without any further questions, I want to tell you that we are here for you. We have live customer support team that's available to answer your questions. So you can call whatever questions you have. You can also email us at info or at support at monmouthOceanRealtors.com. If there's any way that we can help you sell more, we hope to do so. And if you have any questions about this at all, feel welcome to give us a call. We're glad to do that. Thank you again, and we look forward to serving you in the future.